Sir John, you were the 12th Goodhart Professor to be interviewed for the Eminent Scholars Archive. You retired in 2016 as a Lord Justice of Appeal, having risen through the ranks of legal practitioners and the judiciary, where you started as a barrister in 1971. You've been the Goodhart Professor of Legal Science for the academic year 2016-17. And we are very grateful to you for agreeing to share some reminiscences of your life and your career, as well as your experiences here in Cambridge over the last year. After summarising these activities, I hope that you can give us some thoughts on legal topics and notions with which you've become associated through your published writings, particularly some topical constitutional issues. So could we start with your early life? You were born, Sir John, on the 10th of May 1945 as the Second World War ended.
Yes, I was. That was 2 days after VE Day. Apparently I was late and my mother was very angry that she missed all the parties.
Where were you born?
In Nottingham, where my mother's parents lived at the time.
Were your parents involved in the law?
No, they were both doctors. They were both in the Royal Army Medical Corps in the wartime, serving in Egypt. My mother came back pregnant, and she had one of these strange things that apparently happen in pregnancy. Every time she saw a particular steward on the boat, she was sick, but not otherwise.
From 1950 to 63, you were at school, first at Durham Cathedral Choir, and then at the secondary Durham School.
Mm-hmm.
Any mentors that stand out from that period?
Well, there were very good classics masters at Durham School. One was called Bobby Smithson, the other was a school chaplain, a chap called Jack Marston. And I think and also the Latin and Greek I learnt at the choir school, or prep school, gave me a love of the classics, the ancient classics, which I've always had.
What, at that point, were your main academic interests?
Latin.
Latin.
That's surprisingly, no doubt, but it was. I greatly disliked sport and still do.
In 1963, you went up to Exeter College.
Yes.
And you graduated in 1967 with your BA. And you wrote in 2004 that Lord Birkenhead's biography, and I quote, led me, for the little that it is worth, into the law. And I wonder if you could expand on the circumstances of this very important event in your career.
Well, my father had a copy of the really rather poor biography of F.E. Smith, Lord Birkenhead, that had been written by Birkenhead's son. And I read it, or perhaps I only read some of it, and I don't recall, as a young teenager. And I suppose I thought that, as teenagers perhaps are inclined to, that this was a very romantic profession with a lot of contest in it. And I remember announcing to my grandfather on August the 1st of my 13th year that I was going to be a barrister. I know it was August the 1st because that was the day we always went up to northeast Scotland for the summer holiday.
You list philosophy as one of your interests in Who's Who. Mm-hmm. Did you read philosophy at Exeter? I
read what at Oxford is called Greats at Exeter College, Oxford. That is to say, the ancient classics plus philosophy. And the course included quite a lot of modern philosophy. So I've been particularly interested ever since then in moral and political philosophy, which I think are disciplines that are intertwined with the law. And they've made a great deal of difference to my approaches to the law or views about the law, for what that may be worth.
Any influential teachers or lecturers that you remember from Oxford?
Yes, two. There was a young Canadian called John Baker who was teaching the modern philosophy. And I don't remember any particular incident, but he was a very good teacher, very clear, very precise, and very encouraging. The ancient history tutor was an older man called Dacre Balston, who was a very well-known teacher amongst classicists. He was what you might call an archetypal bachelor don. The first essay I wrote to him wrote for him was on Greek colonization, I think. And as was the tradition, the undergraduate reads the essay to the Don, who listens and then comments on it. And as I read this essay to Dacre Balston, he blew perfect smoke rings from his very long cigarette holder. And at the end of the essay, he said, "This essay is like a souffle that hasn't risen." Now, after that, I'm sure I wrote other bad essays, but none that were quite so boring.
Sir John, what were your ambitions for a career in law at that time?
I don't know if I looked ahead very far. I certainly wanted to be a successful court advocate, the traditional route for the bar. I don't believe that when I was an undergraduate or a student, a law student, a little later, I had any particular focused ideas about the bench. That came a bit later on. So my energies were concentrated on practice at the bar in the traditional way, really, of common law chambers.
So how did you proceed after your BA?
Well, I took the degree, the Oxford Finals in '67. I then came to London and was already a member of the Inner Temple, having decided to go to the bar, and went through the bar exams and was called to the bar at the Inner Temple in 1970, pupillage 1970 to 71, and then I remained in the same chambers, general common law chambers they were, throughout my career until I went on the bench in 1992. As I say, they were general common law chambers, so one saw a very wide range of practice. But after some years, I got more involved in public law, administrative law, because as a more senior person in my chambers, now Lord Brown of Eton under Hayward, was the what's called the Treasury Devil, that's to say the advocate, the member of the bar who is instructed in the major civil cases on behalf of the government, whatever political colour it may be. And so some of the work he couldn't do for the government filtered down to me, and I succeeded him as Treasury Devil in 1984. And after that, I was doing a lot of public law cases, and that became my major interest, I suppose.
Thank you. Coming then, Sir John, to your legal career, you've had a very illustrious career. You were called to the bar of the Inner Temple in 1970, having left Exeter College in 1967.
That's right.
And were those 3 years spent studying for the bar?
Yes, mainly. I did a little teaching back at Oxford. I was asked to go back and teach some undergraduates on a Saturday morning for the philosophy part of the grades degree. So there was that. I also did a bit of ad hoc teaching in London. Otherwise, I was pursuing the bar course, which I did in quite a leisurely fashion. Though I didn't fail any exams, I think I had some gaps between one and the next one. So I was called, as you say, 3 years after finishing at Oxford in 1970.
And why did you choose the bar rather than a career in academia?
Because I thought that it would be interesting and rewarding and fun to be a court advocate.
You were a barrister at common law from 71 to 92, 21 years. What cases did you specialise in?
Well, after some years, I became more and more interested in public law and had a number of cases for the Crown and then I was appointed to be Treasury Devil in 1984. And the Treasury Devil is an exception to the cab rank rule of the bar, because he doesn't take any clients other than the government of the day. Whether or not there's an election, the government changes, the Treasury Devil continues, acting only for the government. And most of the cases then were public law cases. At that time, judicial review was beginning to come into its own. There were also quite a lot of cases, well, certainly, yes, a fair number of cases in the European Court of Justice, where I went maybe a dozen times, and one or two visits to the Strasbourg Court as well. In previous years, the Treasury Devil had possibly, I'm not sure about this, had a wider range of work because there was less public law, administrative law work, so the Treasury Devil might do some of the heavier personal injury cases or other litigation for the Crown. But by my time, in the second half of the 80s, judicial review was very much the coming thing. And during that time, I was involved in the Spycatcher litigation, which took me to Australia. I was involved in the Death on the Rock inquest in Gibraltar, which took me there to Gibraltar, and a large number of cases in the Court of Appeal and the House of Lords here at home.
Very interesting, Sir John. That to some extent explains your foreign qualifications.
Oh, at the bars of New South Wales
yes.
and yes, it was
yes.
because of those two cases.
Right.
It was necessary to be admitted to the local bars in order to take part.
I wondered about that. You were in 1984 to 92 the first junior Treasury Counsel.
Yes, that's the Treasury Devil.
That's the Treasury Devil. And this was during the Thatcher and the Major years of government.
Mm-hmm.
And I wondered whether this is how did you make this job? Did you apply for this position?
No. The system is that and has been since, I think, the early 19th century, certainly a long time. The Treasury Devil is appointed by the Attorney General. I've never heard of anyone applying for the job. I suppose there's nothing to stop you writing to the Attorney and saying, make me the next Treasury Devil, but I don't think it would increase your chances very much. And by the time I was appointed in 84, I had done quite a lot of government cases, the cases which the then Treasury Devil couldn't do because he'd be in 2 or 3 places at once. It's a very busy job. And as had a lot of other barristers, there was a panel, and indeed there are 3 panels now, I think, of barristers doing government work, so to speak, under the Treasury Devil. And that means that the Treasury solicitors and the Attorney General's office get to know the various members of the bar who are doing government work, and also they'll see members of the bar appearing against the government. So they get quite a pool from whom eventually the next Treasury Devil will be selected, and that was me in 84.
Right. You dealt with these governmental matters for 12 years, and looking back, was the work particularly political during this period?
It wasn't 12 years, 84 to 92, by my arithmetic, is 8.
8 years.
In fact, it was about 7.5, I think. But
right, thank you.
Particularly political. Well, that I think depends what you mean by political. It wasn't, I was not concerned with what you might call party political disputes at all. I was concerned only with, obviously, the litigation that the government got involved in. Now, that could be highly political in one sense. I mean, cases like the Spycatcher case could be said to be political. How far should the state censor people who want to write about the security service? The Death on the Rock also could be said to be highly political. The background of it was ultimately the Irish Troubles and the efforts of the IRA in that case to commit murder and destruction in Gibraltar. Other cases, there were a lot of Home Office cases, prisons, a lot of planning cases for the Department of the Environment, or many could be said to be political with a small p sense. And the work was very varied across the departments of state.
Sir John, in 92, you were appointed as Judge of the High Court.
That's right.
Queen's Bench, having served your apprenticeship as a recorder. Do these appointments take place by invitation, or do you apply to become a full-time judge?
Well, the system's changed since 1992. In 1992, and for a little while after, I think, the appointment of to the High Court is by invitation by the Lord Chancellor, although the appointment is made by the Queen on the Lord Chancellor's advice. Now, as is well known, there's a Judicial Appointments Commission. Applications are invited, and there are quite extensive, if not exhaustive, procedures for such appointments. But in my time, it was by invitation. However, it's been the convention, certainly since the 19th century, that the Treasury Devil, unless I suppose he or she misbehaves himself in some way, is offered a High Court judgeship after he has done, or she has done. There hasn't been a Lady Devil yet. I'm sure there will be soon. After he's done 5 or 6 years, I did 7.5, which was longer than the average. There was one Treasury Devil in the 20th century, but only one, who didn't go onto the High Court bench. And that was a man called Valentine Holmes, who was Treasury Devil during the Second World War. And it's said that there were a lot of furrowed brows at the prospect of him becoming a High Court judge, largely, I think, because he was fond of going to the dog races with his clerk. Why that should have put people off, I don't know. But the truth may be he didn't want to be a judge. All the others, however, have become High Court judges.
You were knighted during this period.
Yeah.
And was this, presumably this was a momentous occasion?
For me, certainly, yes. Involved a private audience of the Queen, which to any loyal subject would be momentous, I would imagine.
Any recollections of the occasion? I
remember it very well, but of course I will not describe my private conversation with my sovereign.
So, John, are there any...
Oh, I should have had a very good lunch with my wife afterwards.
Are there any highlights or general impressions that you can share with us that cover these years?
The years on the High Court?
Yes.
Yes, there are one or two things. The High Court judges, or there are exceptions and the system has changed somewhat, but broadly the High Court judges go out on circuit around the country, England and Wales. They spend about half their time, did then, in London in the Royal Courts of Justice, and the rest going out to various provincial centres. And I went out on circuit a lot, from Newcastle in the northeast, where I went as often as I could, really, because I'd come from that part of the world, and also the judges' lodgings were very delightful up there, down to Winchester in the southwest. And I greatly enjoyed going out on circuit. My wife came with me a lot of the time. You meet the local circuit judges, the high sheriffs, sometimes magistrates and other local people. You get to know bits of the country that perhaps you wouldn't have got to know otherwise. That was a very good experience. The other thing I'd mention is sitting in what is now called the Administrative Court, then the Crown Office list, and doing public law cases, the sort that I'd done as a barrister. Now I was doing as a judge, and much enjoyed it.
After 7 years of being a judge in the High Court, in 1999 you became a Lord Justice of Appeal,
Mm-hmm.
and presumably one of the qualifications for this is to have been a High Court judge.
It's not a statutory or necessary qualification. It's possible legally to be promoted direct from the bar to the Court of Appeal. Indeed, Lord Wilberforce, Lord Radcliffe, many years before, was appointed direct from the bar to the House of Lords. But my wife will get it. The customary cursus honorum is from the High Court to the Court of Appeal. So excuse me. Can you manage, darling? Okay.
So, John, is there anything you can tell us that might epitomise your role over this period, in which there were some very interesting political developments, both locally and internationally?
Well, I remember some particular cases. The one that interests the academics most is a case called Thoburn, known as the Metric Martyrs case, in which I gave a judgment describing and explaining, as I thought it to be, the power relationship between Brussels and Westminster. And you won't want me to go into the technicalities of the judgment, but that was a case that's, if I may say so, of some importance, or the subject matter is of some importance, in relation to the extent to which our membership of the European Union affected our national sovereignty. And on my view, it affected it a lot less than is thought by others. So that was quite an important case. One other I would mention, a case called Witham, the case in which the then Lord Chancellor purported to increase the court fees by a very considerable percentage, thus preventing some people from litigating at all in areas where there was no legal aid. And we held, that's to say, Lord Justice Rose and I, that the order was unlawful because it effectively prevented access to a constitutional right, namely access to the Queen's courts. So those two are perhaps quite important cases. The third one was a case about the Chagos Islanders, in which I held that the order in council to move the Chagos Islanders was unlawful. And at first the government were not going to appeal against it, but then I think they did, or they made another order, and the saga went on for a long time.
Fascinating. Before we come to your visiting academic positions, just to conclude this section, during your career, Sir John, you've reached high judicial office. What would you say were the most significant legalistic developments that occurred during your career?
I should have thought the development of human rights law is probably the one that particularly comes to mind. As is well known, we've been signatories to the European Convention on Human Rights for a very long time, since the 50s. But in 1998, the Human Rights Act brought the rights in the European Convention into domestic law so they could be litigated in our own courts. And that has really transformed the tensions and relationships between claims of citizen and claims of government. Areas like the deportation of foreign criminals who may seek to resist the deportation on the grounds they've got children here, fair trial issues, sending people away to places where they claim they might be tortured. All these are issues that have proved extremely lively and are all, so to speak, children of the Human Rights Act. The Human Rights Act, I think, has been a great force for good, but it has also had its dangers. I said in a lecture once that human rights are like the human heart. The bigger they get, the weaker they get. And I think there's some truth in that. I think we have sometimes elevated the claims of human rights to a point where the public interest has been diminished. But that would be a long and big conversation, and the devil would be in the detail.
Coming then to your visiting academic positions, over the years you've been a visitor at various academic institutions, Northumbria, you've been an honorary fellow at Robinson College and Exeter College.
That's right.
These might be considered standard academic positions. Is there anything that stands out from any of these situations?
I wouldn't describe honorary fellowship of an Oxford and Cambridge College as standard in any sense. I think it's extremely honorific, and have been very delighted to have had those honours. particularly this year when I've been in Cambridge as the Goodhart professor. That has allowed me to go very frequently to Robinson, to make new friends there as well as meet old ones. I was dining there, a very informal dinner in the senior common room last night, and that has given me much pleasure. And I hope that when I'm finished here at Cambridge, I will maintain those links in a lively fashion. So that's as regards the fellowships. The Oxford Fellowship was of my own old college. I gave one of my Hamlet lectures there, and I've greatly enjoyed being an honorary fellow there as well. In 1964, when I was an undergraduate at Exeter, my now wife and I went to the commemoration ball, which was to commemorate, was it 600 years? Yes, that's right. 600, the 600th anniversary of the foundation of the college. And then in 2014, 50 years later, we went to the Commem Ball again to celebrate the 650th anniversary of the college. So that was great fun. But that's entertainment rather than work, so to speak.
So, John, could you tell us something about your association with the Cumberland Lodge?
Cumberland Lodge, yes. Cumberland Lodge is a trust. It occupies a Grace and Favour House in Windsor Park. It was a royal residence in the wartime, the Second World War, 1943, I think. Queen Elizabeth, later the Queen Mother, read a book by a woman called Amy Buller called Darkness Over Germany. She was a lady from Liverpool, I think, or she worked at Liverpool, who knew the German language very well, had German friends, and visited Germany a great deal during the early years of the Nazi era. And she wrote this book. It's just been republished. I haven't read it yet, but I'm going to. Essentially about the influences that she saw had brought the Nazi youth under the Nazi flag, so to speak. And the Queen Mother was so impressed by this, and I think the King read it too, that arrangements were made after the war, 1947, to hand over this house, Cumberland Lodge, to a trust to be run by Amy Buller to bring together young people in this country. Essentially what, for want of a better expression, you might call a Christian flavour, but the idea is that the young people from the universities and elsewhere should come, should learn, should think, should talk freely, should understand different and conflicting ideas. And that has been going on ever since. I first went there as a bar student in 1969, I think, because each of the four Inns of Court sent their students there for 2 weekends a year. And I got to like it very much and went back several times. Later, when I was at the bar, getting quite senior at the bar, I ran the Inner Temple Committee that organised the weekends. And then 3 or 4 years ago, a few years ago, no more than that I think, I was appointed visitor of Cumberland Lodge in succession to Princess Margaret. The visitor doesn't have to do any duties or would, or unless there's some terrible fallout between the principal and the trustees or something. It's very unlikely. It certainly hasn't happened. But it means I've maintained a very strong link with the place. I was lecturing there last week about extremism, and it's a very I don't know what word to use really, other than excellent. It's a splendid, worthwhile institution that does a great deal of good.
So, John, you're coming to the end of your time in Cambridge.
I am, I'm afraid, yes.
And could you summarise your activities and give your impressions of your year here, starting perhaps with the topics that you taught?
Well, I gave a course of lectures over 2 terms on the subject of judicial review and the rule of law to third-year undergraduates. I learnt a great deal preparing those lectures. I hope the students did too. I'm in the middle of marking the papers. it's been, for me, a very interesting and worthwhile experience teaching the young as opposed to dishing out judgment. It's very different but strangely similar. In each case, you are hoping that you will persuade those who are concerned that you're right. Of course, if you're the judge, your word goes, subject to any appeal. But you still want those who are concerned to think, yes, that's the right intellectual answer or the right moral answer. And of course, you feel the same teaching students. But I think also you learn a lot because you may have thought some particular point to be obvious for 20 or 30 years. And then somebody may say something in class and you think, oh, maybe it's not so obvious after all. So teaching, I think, is a kind of youth drug. It keeps you intellectually curious. So that's one thing. The other thing I would say, and I would particularly emphasize this, is my wife and I are both Oxford graduates, as it happens. We have been made hugely welcome here by the other members of the law faculty, by the staff at the law faculty, by everyone at Robinson College, and by others. My wife has joined a couple of groups here in Cambridge. They've been very welcoming. We could not, I think, have been more kindly and generously treated.
Did you come here originally with a particular plan of collaboration with anybody in the faculty?
I corresponded with Professor David Feldman and with one or two others, and it was necessary to decide before I started last October what I was going to do, how I was going to use the year. So I had decided before October that I would give this course of lectures. And as regards that, I've been greatly helped in the administration and in discussions and in every possible way by others in the law faculty. Professor Feldman has been involved with me in running the lectures. It's me that's given them, and he could not have been more helpful.
Any overall conclusions of opportunities that the chair presents?
Well, the chair, I hope this is right, is designed frankly, to leave the Goodhart professor quite a lot of time to decide what to do himself. And I think the idea is that it's an opportunity for your own research or writing. Now, I've not exactly been doing any research, but I am hoping, and I've started, but it's an early stage still, to use this course of lectures as the foundation for a book, which will be certainly about constitutional law, but it'll be about the morals of constitutional law, if that makes sense. We'll have to see what the book says.
So that will be your next project when you leave
I think
Cambridge?
so. I've got one or two other things to do, the odd lecture to give, but that would be a project over some little time, yes.
Any other plans?
I've got a novel in my head to write, but I'm not going to tell you about that.
Well, that sounds very interesting. Could we touch on some broader legal topics now? Your views on major legal issues. You've written several books and chapters in books, as well as numerous journal articles. Could we briefly talk about the topics which have interested you especially? I've looked, Sir John, as best I could at some of your output, and several themes seem to stand out for me: judicial review, constitutional matters, Wednesbury, and unreasonableness.
Yep.
Yet your first publication, listed in your Who's Who, was in 1977, and a Dictionary of Medical Ethics. This stands out from your other, and I wondered...
Yeah, maybe the entry is misleading. I hope it isn't. I didn't write the whole dictionary. I contributed one small piece in it, and I can't remember what it was about. It was 1970 something, I think, 77 possibly.
Yes.
Yes, it's a long time ago. I've got it on the shelf somewhere. But it's travelled into the distant fog of memory.
Two areas in which you've written widely are judicial review
Yeah,
and the unreasonable test in Wednesbury.
yeah.
How did it come about that you found these topics so very worthy of your attention?
Well, out of my practice at the bar and on the bench, judicial review was the bread and butter of my work in the courts. It interests me in principle because it is about the relationship between citizen and state. It's therefore about the difference between a free society and an unfree society. And that difference seems to me to pervade so much of the important issues that we confront in the modern world, very obviously. Here in England, we have a constitutional balance between the courts and the elected government. If the balance goes too far down in one direction, you will get the government dictating to the people. If it goes too far down in the other direction, you will get the courts elevating human rights above the general interest. It has to be kept in balance. That interests me from the political, moral, and legal point of view. And it is a constant struggle to keep the balance. So far, we've not done too badly. No doubt there's always room for improvement.
Your interest in matters constitutional has become very topical because of potential changes flowing from Brexit and the imminent modification of the status quo compared to when you wrote your articles. It would be fascinating to know your views on these issues, Sir John.
Well, as far as Brexit is concerned, I have no particular voice on economic matters or the difficulties that are going to be encountered in the negotiation. I can only speak about constitutional questions. One thing that troubles me very greatly has been the use of the referendum. Not, I don't mean because of the result, I mean because of the institution of the referendum. If you have important questions effectively decided by the popular vote through a referendum, you are setting up a democratic poll that is in opposition to another democratic poll, namely representative democracy in the form of the parliament, the legislature. You are having direct democracy and indirect democracy vying for position. It's well known that many members of parliament in both houses felt in their own political consciences that Remain was the right answer, but they voted for the bill that authorised the Article 50 decision in light of the referendum result. Now, what is a representative politician to do? Is he to follow Edmund Burke and give his electors the benefit of his own conscience? Or is he merely to act as a delegate, which it could be said is what is being done if MPs simply follow what a referendum has told them? I think this is constitutionally troublesome. It may be that because of the very particular acute importance of the Brexit issue, it was justified to hold a referendum. I have not a fixed opinion about that. I think it's probably easier to justify the referendum that took place in 2014 on Scottish independence, because that was actually about the breakup of the United Kingdom. But whether or not the Brexit referendum was itself justified, setting up these opposing polls is, I think, constitutionally troublesome. That is the first thing I would say. The only other thing I would say is that I've always thought it a mistake to assert, though it is very often asserted, that our sovereignty was diminished by membership of the European Union. What actually happened when we passed the European Communities Act in 1972 is that Parliament delegated the lawmaking power to Brussels institutions. That's the consequence of Section 2 of the statute. Since the European Communities Act can be unmade just as it was made, we have not lost the sovereignty of the power to legislate for ourselves. That's easy to say, and I'm not suggesting that unravelling Brexit is going to be in the least straightforward, but it's important constitutionally to recognise that fact.
In 2012, you wrote an article entitled "The Good Constitution," published in the Cambridge Law Journal.
Yeah.
And you said that the British constitutional system is evolving from one of parliamentary supremacy to one of judicial supremacy.
Don't think I did I? I think I may have said it is moving from a parliamentary supremacy to a constitutional supremacy. Is that not what I said? This is the David Williams lecture I gave in May 2012. I certainly wouldn't assert a judicial supremacy. I do think that the sovereignty of Parliament needs to be balanced by the importation of basic constitutional principles, fairness, reason, and the presumption of liberty. Unless Parliament legislates in accordance with those principles, it betrays the people, because it's not acting then in accordance with the principles that are needed to protect the people.
In that article, you cite Professor Bogdana.
Yes, indeed.
As saying that since 1997, the Human Rights Act, together with membership of the EU, has provided us with a new British constitution. Do you think this is desirable, or is this process irreversible?
I think we have an evolving constitution. The feature of British public law, constitutional law, for which we should frankly be most grateful, is its ability to evolve without revolution. We haven't had any revolutions since the 17th century, but we have had enormous constitutional development since then. The enlargement of the franchise, in the last half century, the growth of public law, judicial review in particular. These things are able to happen because the common law is always the same and always different. It can evolve while retaining its essential core. That is something which moves me to believe that it would be a very bad mistake to have a written constitution, because a written constitution places all the wisdom of the state in a single moment, whereas, of course, as Burke said, society is a contract between the living, the dead, and those not yet to be born, and the methods of the common law reflect that, and we are very fortunate that that is so.
So, John, in the same article, page 582, you say that without democracy, law is the puppet of tyrants, while without law, democracy is mob rule. Do you see judges acting as neutral arbiters in this tension? And would this be the, and I quote, rule of reason that you mentioned in your 1998 Wednesbury book chapter?
Oh yes, the rule of reason. Judges are not, they are impartial arbiters. They are not neutral arbiters. They're impartial because they will not favour one side over the other for the sake of doing so. They are independent, obviously, for the same reason. Neutral is, however, a different concept. Neutral might mean that they do not bring any sense of particular values to their task, but they most certainly do. They are reason, fairness, and the presumption of liberty. It is because of values of that sort that they will interpret a statute in one way rather than another. They are impartial, therefore, but not neutral.
I found your Hamlin lecture booklet, which you mentioned earlier, particularly interesting, published in 2014, entitled The Common Law Position, the Hamlin Lectures, CUP.
Yeah.
It has many allusions to the UK's position in the EU and vis-à-vis the European Court of Human Rights. Could we just finish with some consideration of issues that arise therein, and I'll focus just on the first and the third chapters.
Yes.
In the first chapter, Common Law and State Power, you emphasise how social change has helped modify the common law. And interestingly, I've just recently interviewed Professor John Baker.
Oh, yes.
And he, on this very issue, and he says that in an historical sense, as it pertained to, say, Tudor times, he said he found the linkage was problematic. He says it is not as straightforward as social historians sometimes assume. And I wondered if you could comment on that, Sir John.
I'm sure he's right. The effect of social change on the law, or the law on social change, is not straightforward, but it is a feature of the law that it is ahead of its times and behind the times at the same time. It's behind the times because there's an extent to which, as judges are not elected, they have to be careful when and how they react. They must not be policy leaders. On the other hand, they have to be ahead of their times, because they may see constitutional difficulties on the horizon, and they can sometimes give warnings through their judgments about that. It is a process that is difficult to describe because it has so many facets. But essentially, this is all about the methods of the common law. They are precedent, history, the distillation of ideas over time. The law, as I said before, is always the same and always different. And that's why it is possible for social change in the law to interact in a way that is not, so to speak, socially violent.
Still, the chapter on common law and state power on page 24, you say that judges must not lay down general principles. They can only relate to the facts of the case before them. To do otherwise is to encroach on a legislative function.
No, that's a quotation from Lord Sumption, who is speaking about the French judges. And if the English judges were like that, I think, well, I mustn't be rude about our continental friends, but I think we are luckier.
So, John, the third piece in this book is on the common law in Europe. Very interesting indeed. And on page 57, you mention Lord Denning, who likened the EU treaty to an incoming tide.
That's right.
Which he implied could not be held back. Do you think that the tide will now ebb once the 1972 Act is repealed?
Yes, plainly. The tide will ebb. Whether it will go out entirely is another matter. After the election last week, there's increased talk about Brexit taking perhaps a different shape than had been anticipated by some. I'm in no position to predict what the outcome will be, whether the European Court of Justice will retain some kind of jurisdiction over some affairs here after the 2-year period is finished. I don't know. But certainly the tide will ebb, otherwise there'll be no Brexit at all.
Page 80, you say that although the Human Rights Act cannot force courts to abide by European Court of Human Rights decisions, because the UK has signed the Convention, Article 46.1, we must follow their case law in cases which involve the UK. So if cases are still sent to the European Court of Human Rights after Brexit, the Constitution can presumably still be strongly influenced by European judges.
Well, it'll continue to be influenced by judges of the Strasbourg Court so long as we remain signatories to the Council of Europe. But it is to be remembered that the Council of Europe and the European Court of Human Rights is not part of the European Union at all. It is not dependent on our membership of the European Union. And if as is presumably to happen, we leave the European Union, we will remain members of the Council of Europe unless we separately withdraw from it. So that will not change. I have an issue which I think I discuss in that lecture about the extent to which we should be following the jurisprudence of the Strasbourg Court. Obviously, in a case that goes from Britain to Strasbourg, our international obligations through our membership of the Council of Europe oblige us to abide by the result. But that is not the same as saying we have to follow the jurisprudence in every other case that Strasbourg decides, whether it's to do with Article 8, family life, or whether it's to do with Article 3, torture, or anything else. And I think, as I've said before, that our own courts and tribunals have sometimes, I fear, been too slavish in following the Strasbourg jurisprudence. Section 2 of the Human Rights Act obliges our courts to take account of the Strasbourg jurisprudence. That does not, to my mind, mean the same as agree with it.
Perhaps an unrealistic request, but could you look into your crystal ball and say what, if any, fundamental constitutional changes might ultimately flow from Brexit?
Well, if there remains, I suppose it depends entirely on the terms on which we come out. There may be implications still arising out of Brexit for the independence of Scotland, although the political picture has changed so rapidly in relation to that one really can't say. That aside, I would have thought that there is nothing of a fundamental nature that our constitution that will change our constitution. Partly because we've never lost the sovereignty to legislate for ourselves. Our court system may be strengthened. There may be bigger issues being decided finally by our Supreme Court. That's a possibility, I suppose. But otherwise, I would not see further than the outside of the crystal ball.
Thank you very much, Sir John, for an extremely interesting account. I'm
Great pleasure.
Very grateful to you.
Not at all.
Thank you.